SJC-12152, Commonwealth v. NM.
Mr. Mezer, good morning.
Good morning. May it please the court. I'd like to begin with the amicus brief recently filed on behalf of CPCS Youth Advocacy Division, written by Robert McDonnell, Vanessa Brown, and Josh Silverstein. That brief sets forth some of the developmental, educational, and mental harms that alleged youthful offenders suffer when they are indicted. It also explains why pretrial appeals like this one are necessary and important to preserve juvenile rights and protections that otherwise can't be remedied on a post-trial appeal.
So precisely which kinds of matters should be allowed to, motions to dismiss right now are not subject to a direct right of appeal. Denials of motions to dismiss are not subject to a right of appeal, except if they have to do with double jeopardy. That's our case law so far.
That's your case law.
You're looking for an exception or an expansion to a second category. How would you say, what is that category that you want it expanded to?
A category of a case like this, where a juvenile makes a substantial showing that he or she should not be tried as an alleged youthful offender, that he or she should not be subjected to things that he or she would not be subjected to if he or she was tried as an alleged delinquent child, particularly a public trial where they lose their privacy, and particularly a trial at which, in this particular juvenile's case, she could be subjected to an adult punishment of up to life in prison.
So is it always, whenever a juvenile is brought before a grand jury and the question is whether or not this is, whether or not the elements or the conduct presented is sufficient to make out a case that this is a youthful offender? You saying whenever that happens, there's a direct right of appeal from a denial of a motion to dismiss?
I think that the law should be as it is now, which is that the juvenile can file a petition under 211(3) with a single justice, and if the single justice denies that petition, the juvenile can appeal to this court, and the first step in that appeal is filing a memorandum under your Rule 2:21 sub 2, explaining why post-trial appeal is not going to be an adequate remedy. Now, that was the procedure followed in the Felix F. case, and that's how the Felix F. case got to you, the full court.
But the judge in that case, Justice Spina, said in deciding the 211(3) on the merits that there was no adequate remedy on appeal. He himself, that's how he decided it on the merits, and then he denied the request under 211(3), but it was on the merits. It wasn't, in this case, Justice Spotsford did not decide it on the merits.
Correct. But I would submit, number one, that your rule does not distinguish between decisions by the single justice on the merits and summarily, number one. And number two, the procedural posture that Felix F. found himself in is precisely the same procedural posture that this particular juvenile finds herself in, and the same rights and the same considerations apply. Having said that, there are cases where double jeopardy issues have been argued to this court, And there are situations where this court has dealt with them relatively summarily. When jeopardy hasn't really attached, or when the evidence at the first trial was clearly sufficient. And I would submit that you're not opening the floodgates here. The same considerations should apply. If there's not a substantial claim of denial of rights that can't be remedied on appeal, you can deal with that issue summarily.
What happens on the appeal if the single justice agrees, well, this is, if there were error, this would be irremediable error, but that there's no clear violation of a substantial right? Would there have to be an appeal in that situation?
Let me make sure I understand you. If
Not a double jeopardy is raised, okay? So that's clearly enough. But the single justice says, well, there's no substantial right here. I've looked at this. Is there still an appeal to the full bench?
subject to your Rule 221 sub 2 memorandum, which requires the appellant to submit reasons why, notwithstanding what the single justice may have said or not said, reasons why this particular type of appeal, it presents something substantial that ought to be heard and decided by the full bench.
And when you say something substantial, in your view, there would always be irremediable harm, but you would say that there must be a substantial showing that you very well might prevail.
Pretty much, in the same sense as a double jeopardy appellant would have to show some substantial claim that double jeopardy may apply and that the double jeopardy argument might prevail.
Okay, can we turn to, can we turn to the merits if
Absolutely.
you do get past that? Is it would this be a different, well, let's go to the issue of infliction or threat of serious bodily harm. Does it matter here that the touching was by the finger in the vagina as opposed to a penile penetration?
I don't think it matters that we're dealing with a female juvenile versus a male juvenile. And I don't think it should matter that much just how deep the penetration may have gone, if you will. Because your cases say that a rape case can be made based upon an external touching rather than an internal touching.
What about the age discrepancy?
The age discrepancy, which in this case is almost 8 years, is something which your cases have considered as aggravating factors. Now,
How old were the children when this began?
Pardon me?
How old were each when this began?
When this began, allegedly, the alleged victim, who was the juvenile's cousin, was about 6, and the
Said
juvenile...
5 or 6.
5 or 6, and the juvenile was about 14.
So it's substantial.
Yes,
Okay.
it is substantial, I agree. Now, in the particular circumstances of this case, where the grand jury heard affirmative evidence that the cousin was advanced for her age, words I think were used were very intellectual and very well spoken, maybe the age difference is not as great as chronology might.
Wait, the
But that was
5
when
and
she was 9.
the 5 and 6 year old was advanced for her age?
Yes, correct. But I'm not really relying on that. What I'm saying is that the cases have looked to what they have called the invasive nature of penetration and have looked at what the the juvenile did, what her conduct was, and how that conduct affected the alleged victim to determine whether or not there was a communication.
Apart from the number of the age discrepancy, isn't there a huge developmental discrepancy between a 5-year-old and a 14-year-old, or a 6-year-old and a 15-year-old?
The simple answer is that's not reflected in the grand jury minutes, number one.
Kind of common sense, isn't
And,
it?
well, and and perhaps you would be right were it not for the affirmative evidence that was in front of the grand jury that this particular 6-year-old, who was 9 by the time anything was reported, was advanced for her age.
Well, she said that it hurt sometimes. She said sometimes she didn't want to do it. She felt like she had to lie about the 2 boys walking by. So if you take all that into account, are you suggesting that we just look at an element-based approach, or is it a conduct-based approach?
First answer is no, you're looking at the conduct-based approach. Second thing I'd like to say is the points that you mentioned about that maybe it hurt, that comes not from the grand jury minutes, but from the video of the interview of the alleged victim, which was an exhibit before the grand jury, but as far as the minutes reflect, it wasn't read by or referred to by the grand jury. It wasn't something that was in the record below, including at the single justice level. And again, there was evidence, affirmative evidence, which the grand jurors heard to the effect that there was an understanding that whatever conduct was going on would stop if it hurt.
Well, let me ask you this to follow up on Justice Lowy's question. Are we looking at the fact that this was rape, and therefore any rape of whatever name or nature fits within the youthful offender statute, or do we look at a case-by-case basis?
You look at it on a case-by-case basis based on the evidence of the juvenile's conduct and its effect on the alleged victim. And here it's very significant that this alleged victim, this activity allegedly continued to occur on a regular basis in the petitioner's bedroom, in a house where adults were present, and while the girls were resting after they had attended dance class together, and it continued for about 3 years before any complaint was prompted. And
The child was 6 years old.
well, what your cases talk about, if you look at the Clint C. case and the Todd case, which was an appeals court case, on the one side, and your case of Quincy Q. and Washington W. on the other side, I think that there's a distinction that can and should be made. In both Clint C. and in Todd, there was a significant age discrepancy like here. And in Clint C., there was an additional aggravating factor, which was that the juvenile was supposed to be babysitting. But in each of those cases, there's an abrupt, forceful, and upsetting conduct that occurs that prompts a prompt complaint. In the Quincy Q case and in the Washington W case, there's a more protracted course of conduct. In Quincy Q, the alleged victim was 3 years old, which is even even younger than this alleged victim, and the age discrepancy was 12 years old, which is even greater. But this court said that there was no evidence of a threat or infliction of serious bodily harm. And I submit that one of the turning factors was that there's no evidence of force, just like here. There's no evidence of fear, just like here. And I submit that the fact that there was no complaint for a significant period of time is not to suggest that the conduct was consensual. I'm not suggesting that. I'm suggesting that the fact that there was no complaint for such a long period of time is evidence which, if you will, negates the notion that there was a threat of serious bodily harm.
But you know, are you asking us basically to reweigh what the grand jury in fact heard?
In a way, yes,
And
because...
to say that it doesn't add up even though that they thought it did?
Well,
Because they're not looking at it from the light most favorable to the juvenile. They're looking at it, and we have to look at it in the light most favorable to the Commonwealth, don't we?
yes, you do, but the Commonwealth still has an obligation to present sufficient evidence to establish probable cause, and
Chris, I'm hearing you not talk about the sufficiency of it, but to question whether or not, for example, the report of it for not having reported it for 3 years really just undercuts other things. And isn't that really sort of reweighing what was before the grand jury? The grand jury would have known that.
Well, to an extent, your review of this whole case is a de novo review as a question of law based upon your review of the grand jury minutes. So in that sense, I am asking you to reweigh it.
Well, what about, I mean, I know it's counterintuitive, but the overwhelming majority of child rape cases involve, of this age at least, involve a delayed disclosure. So you're saying that would eliminate, in many situations, if that were the key, the serious threat of bodily injury.
Well, that actually goes back to Justice, I think goes back to...
Bodily harm, excuse me.
I think that actually goes back to Justice Ireland's dissent in the Clint C. case. And you know, he wrote the book on juvenile law. And in his view, the facts there did not support a youthful offender indictment because even though there was a prompt complaint, the juvenile's actions did not amount to a threat of serious bodily harm or to the infliction of serious bodily harm.
Okay, thank you.
Thank you.
Mr. DeRosa, good morning.
Morning. May it please the court, Ron DeRosa on behalf of the Commonwealth.
Mr. DeRosa, before you start, let me just ask you about your brief.
The note, Your Honor?
Yeah.
Yes.
Why do you feel you have to name the juvenile?
Because, well, I think it's unclear because some cases of this court,
Well, if it's unclear, why do you name the juvenile? This case is all about whether it should be prosecuted
this case was
as a
impounded, yes.
youthful offender indictment. So I see no reason to name the juvenile in your brief.
Well, I guess because my premise is that there was probable cause for the youthful offender indictment.
Well,
The judge was denied,
you get to decide that, right?
well, ultimately in this case, yes. But because of the language of the statute that specifically says upon indictment of a youthful offender, it doesn't say upon adjudication of a youthful offender.
Is there no impoundment order in this case?
There was an impoundment order. Your Honor.
And there's an impoundment order particularly as to names?
Of the case entirely, Your Honor.
Right, and so that's on appeal as well?
No, Your Honor, that's not part of the appeal.
No, I meant it applies to this court, the impoundment order,
It applies in this court,
and to
yes.
pleadings. And is this an impounded pleading?
Yes.
All right.
So that's why, I didn't do it as a way to bring it to public attention, my premise is that there was sufficient evidence for the youthful offender indictment.
I'm just saying, why did you have to do it at all?
Well, I guess,
We don't need to know that.
I guess because there's also sort of this conflict, Your Honor, where we have Clint C., we have Washington W. Meanwhile, Keith Todd was, that name's in a published opinion, as well as, I can't think of,
Mogolinsky.
as well as the woman's name, who has the pending case that's down on, I believe the threat, the helping, the assisted suicide case. So I guess I did it as more of a, to bring it to the court's sort of awareness that this is sort of a tension that's going on in the law. I did not do it as sort of a way to out the defendant as, but I would suggest that because the indictment as of this point is valid. And I also recognize that the case was impounded, so these weren't going to be open for public inspection, particularly where this was a 211-3 that was captioned under the initials. So that was my thinking, and that's why I put the note in the brief right up front to make the court aware of this tension in the case law. So.
Well, let me ask you a question on the, we have Felix, and it's different because there the single justice
Reach the merits.
reached the merits because he concluded that there was no adequate alternative. And that being said, then we have the merits decision, which we feel that, the court felt that the single justice got it wrong on the merits.
Yes, Your Honor.
So what if we had another case exactly like Felix on those facts, and it comes before the single justice, and notwithstanding Felix and the decision on the merits, the grand jury comes back with an indictment on just those facts, which is wrong, and it shouldn't. We'll just say it
Yes.
shouldn't. But the judge below refuses to denies the motion to dismiss.
Yes, Your Honor.
Comes up on a 211-3. The judge does what Judge Bosford does here in the sense of just acts summarily and denies the 211-3. Is there no way other than a single justice in her discretion deciding it on the merits and saying, well, this is error and it needs to be tipped, or reserving and reporting it if there's no direct right of appeal?
I think in that scenario that Your Honor just posed, there would be a clear, the court could find exceptional circumstances because, to use its superintendent's power.
Should we, yes, but then,
Under-
but I mean, how? If there's no 221 right?
Finding it was a clear error of law, I guess, would be the way.
So is there a 221 right of appeal under those circumstances?
A right of appeal to file.
right of appeal.
To file the actual memo.
Yep.
Under those circumstances where there's a clear error of law, I would agree that there would be.
Okay.
But in this case where she summarily denied it, there's no clear error of law or abuse of discretion.
Well, that's the question.
Yes, which,
It's hard,
with
isn't
the
it?
court, it's a hard mental gymnastics, the way the rules are set up.
Yeah.
Particularly where, and I would suggest that Justice Spina's footnote in that Felix F. case would give, I think, the way it's written anyway, and I understand it's a footnote and it's not really in depth, by a reading of it, every youthful offender that has his motion to dismiss denied the right to appeal because of the way it's written, simply because of the loss of the juvenile protections, which was what I thought the defendant in this case position was. Because that would open the floodgates, because then every youthful offender who has a motion to dismiss denied would be entitled to review as a matter of right under 211-3, I think, if that reasoning holds.
Well, is that the question, whether or not there's a right under 211-3? I mean, that the single justice must review on the merits?
The way it's set up now, were this court to hold that, were this court to hold
That
the way
the
the footnote is.
exception is expanded to not beyond double jeopardy to include this, you're
Yes,
saying?
I would suggest that it would open it up to all youthful offenders.
Okay.
I would say that And on that point, obviously the juvenile loses some protections if this court were thinking of fashioning a rule under that. I would also point out that I don't think it's required. The Youthful Offender Act has been pending for 20 years. There's been no rule created. It may be something this court would like to refer to the Rules Committee if it's concerned about those loss of juvenile protections to perhaps fashion a rule. But the way I think the law as it stands now, the defendant this court should not even reach the merits of the defendant's appeal.
If we do, could you tell us where the serious bodily harm is?
The threat of serious bodily
The
harm.
threat only of serious bodily harm. You're
Yes, Your
not
Honor.
claiming that it's based on serious bodily harm.
No, there was no injury, there was no evidence of any injury to the victim as part of this.
So was it an
So-
express threat or an implied
It's an
threat?
implied threat of serious bodily harm.
Okay, and where
under
does
this-
that come from?
Under this court's, the conduct-based approach, as Justice Lowy has already pointed out, that this court has looked at to determine whether the factors that this court has looked to in the past to determine, and that's some of which this court has already pointed out. One thing I think, the disparate age difference is obviously big. I think it's even more so when you're talking about in terms of what grades they're actually in. We have a first grader and essentially a freshman in high school looking at the evidence in the light most favorable to the Commonwealth. So I think that puts it in even better context as to what pressures this victim was under when that abuse started.
Well, so there was no force, though, in the digital penetration or associated with the digital penetration, right? I mean, it wasn't like
There was
knocking her to the ground or forcing her
no
to do
force
this.
like that. There was evidence during the team tape that the victim indicated that the defendant did pull the victim's pants down and lifted her shirt up in order to perform the touchings. But that I would argue is some level of force.
Well, let's go to the same tape. There was, I gather, a McCarthy hearing before the judge.
Yes, Your Honor.
And at that time, was the judge given the tape recording of the same interview?
I don't believe he was. I know this is, of course, a 211-3, but the transcript of the motion to dismiss I don't think is part of the record in this case. But
So
it's-
would the same, if it was not presented to the judge below, why would it be part of our record on appeal?
because it is mentioned in the grand jury transcripts, which of course he would have had. He may have just not needed the team tape, but my position is it just provides additional evidence as to
Was
what
it an exhibit? to
It
the
was an
grand-
exhibit before the grand jury. The prosecutor who presented the case mentioned it twice, I believe, to the grand jury that
And the
it was
judge
available.
didn't ask for the exhibit?
To my knowledge, he didn't. The motion to dismiss, Judge, you mean, Your Honor? Yes, Your Honor.
And does the record reflect whether the grand jury had the means to watch the videotape?
It does not. The prosecutor, it said it's available for your review, so I think sort of implicit in that is we can make it available for you to take a look at if it's something you want to take a look at, but
So what do we do on a McCarthy motion where that's the circumstance? Is that part of the record on appeal? or not part of the record on
I would argue it is when we're looking at the evidence in a light most favorable to the Commonwealth and it provides additional evidence. In this case, I don't think you need to get to that evidence because I think the evidence on its own without that was sufficient in light of the other factors going on.
Well, let's go to that. Is it your position that the mere fact that there was an 8-year difference is sufficient by itself to show an implied threat?
I would argue it is in the
So
first grade.
In every case where you have that age differential, there's a per se implied threat?
Yes, I don't think Clint C goes that far, but I would think I would argue that this case is pretty close to the facts of Clint C with the age difference. I believe that was oral penetration as opposed to digital penetration. But I think under these circumstances, I would argue that this big of an age difference, a first grader and a 15-year-old, would be enough of the threat of serious bodily harm.
They were close, right? They had a good
There
good
were
relationship aside from what happened and what the juvenile did. It sounded like to me the first grader looked up to her, she wanted to please her, and it was not so much a threat of harm, but more, I want to, this is my older cousin.
But again, with that goes, I think, sort of an emotional, it's hard to say an emotional coercion on the part of a sixth grader, where, the 6-year-old, I'm sorry, that goes along with that. And even though, again, that again would be looking at the evidence in the light most favorable to the defendant, I respect.
So emotional coercion is an implied threat?
I think it adds to it, Your Honor. It adds to the calculus, the sort of totality of the circumstances that surround the conduct. I also think it's worth pointing out that the evidence was that the disclosure took place after, or when the disclosure took place, the victim had essentially broke down in front of her mother, began crying, and that's when she disclosed it. The mother had also noticed that she began taking a lot of baths at that time. So, all of these factors, I think, go to show that there is a threat of serious bodily harm to the victim in the case.
And what would the serious bodily harm threatened be?
The threat of, even when,
Since,
that there would be harm done to her should she tell anyone.
was there any evidence of that?
There was, in the sense that, she lied to, when eventually, I believe there was 2 twins that had walked by, she became part of the lie to cover up the defendant's behavior when there were 2 twins that had walked by a room and had seen sort of this behavior go on. And when the victim was questioned about it, she lied to, I forget who it was that questioned her about it. So that, and there was also some evidence.
No threat associated with that.
There was no explicit threat, no, Your Honor. She did, and there was also some evidence that the victim said sometimes it hurt. Again, that was during the team tape.
The grand jury probably didn't hear.
But I would suggest, I understand, but I would suggest it's part of the evidence that this court can consider because it was before the grand jury.
So what do we do? I mean, we've got sexual touching among
Penetrate, and again, I think that's a
sexual
distinction.
touching, which
Penetration
includes
versus
some degree of penetration.
versus distinction. I mean,
I understand. But if all that there was here was sexual touching with some degree of penetration and a feeling of guilt on the part of the younger person with the view that there is something morally wrong about it, although she doesn't know exactly what it is, but there is some sense that it is morally wrong, and she went along with it because it was an older cousin who she was fond of. Is that enough to get you the threat of serious bodily harm?
I would argue it is under these circumstances because a person in that 6-year-old's position is afraid of what's going to happen if she were to bring this to light.
Well, isn't the focus on the person who was doing the touching rather than the person who is receiving the touching? I mean, don't we look at what it is that the older child, what she said and what she did that could be interpreted as a threat or an implied threat? Or is it a subjective or an objective analysis?
I think it's probably objective under this court, but I think, well, for a threat of serious bodily harm, I think you have to put yourself in the position of what the 6-year-old would interpret all of these circumstances to mean to her.
So we'd be looking at it from the point of view of basically a reasonable 6-year-old?
I would suggest that's what we're concerned about when we're talking about.
Whether a reasonable 6-year-old would have felt threatened.
By what was going on.
Threatened in the sense of, was afraid of that serious bodily harm would be done to her?
Yes, I would. That's my interpretation of.
Okay, and had there been any history of any kind of physical violence or force as between these two?
Just some just some slaps on her arm to show, I believe that's any physical violence. There was some indication that the defendant had slapped the victim on her arm when she was sort of showing off for her friends. I believe that evidence was in the team tape. But other than that, and the penetration in and of itself. But again, we're looking at it under a problem.
It's not the serious physical harm.
No, Your Honor, no. But again, just to remind the court that we're looking at it under a probable cause standard as well.
Right, and we're looking at it in the light most favorable to the Commonwealth. I think we
Yes.
understand that. Okay, thank you.
Thank you.